This video will provide a general overview and introduction to settlement and negotiation. As a part of the litigation process, parties often wish to avoid the court process in its entirety and look to alternative ways to resolve the matter, ways that are cheaper and less time-consuming. After viewing today's video, you will be introduced to various methods of alternative dispute resolution, such as settlement and negotiation. Before the parties can settle a dispute, preliminary investigative work must be completed. This includes obtaining the client's personal history, health and medical history, calculating damages, and investigating collateral matters such as the attitude of the trial judge, experience with opposing counsel, and the legal case law. Once the preliminary investigative work has been completed and the case has been evaluated, if the plaintiff is considering settlement, the plaintiff's attorney needs to decide whether he or she will be preparing a settlement letter or settlement brochure. The settlement letter contains a detailed account of the information needed for the defendant to understand the benefit of settling the case, whereas the settlement brochure is more elaborate and detailed and often contains pictures and other information which supports plaintiff's case. The idea is to provide the defendant with information that is compelling from a factual and legal standpoint, such that defendant will want to settle the case. Separate and apart from settlement letters and brochures, the court may order or the parties may choose to participate in a settlement conference with the assigned settlement judge. The parties will meet with the judge to see if the matter can be settled without going to trial. If the parties are able to reach an agreement, a settlement agreement is drafted by the attorneys outlining the terms of the agreement. The agreement is a contract between the parties and therefore must meet the legal requirements of a contract. There must be voluntary mutual assent by the parties, legal consideration, the parties must have capacity, and the terms of the contract must be legal. This is an example of what a settlement and release agreement look like. In a typical settlement agreement, the defendant usually agrees to pay a certain sum of money, and in exchange, the plaintiff agrees to waive all claims and release the defendant from any liability. Now, the final method of alternative dispute resolution is negotiation. What is negotiation? Now let's take a minute or two to write down a one-sentence definition of negotiation. A negotiation takes place when two or more people with differing views come together to attempt to reach agreement on an issue. It is persuasive communication or bargaining. One source defines negotiation as getting the best possible deal in the best possible way. Here are some factors that contribute to a negotiator's success in achieving a good result for the negotiator or the negotiator's client. First, the negotiator's case must have some merit to it. If the negotiator or the client do not have a legitimate legal case, it will be difficult to negotiate a good settlement, as the other side will know that you would not prevail if the matter ever went to court for a judge or jury to decide. The negotiator must also have confidence when presenting his or her case. Even if the negotiator's legal case is not that strong on the law, if they are confident in presenting their legal argument, they will have a better chance of negotiating a better deal for themselves or their client. Finally, here are some negotiation tips to consider in future negotiations. Don't be afraid to ask for what you want. Be quiet and listen. You can learn a lot from hearing the other side's perspectives and desires. Do your homework. As the previous slide mentioned, it is important to understand the motivations of your opponent. Always be willing to walk away. It is important not to simply accept what the other side is willing to offer. Don't be in a hurry. When people are in a hurry, they are more willing to accept what the other side is willing to offer, simply because they do not have the time to continue the negotiation. Aim high and expect the best outcome. Focus on the other side's pressure, not yours. This is important because if you are able to focus on the other side's pressures, there is less of a chance that you will accept an offer that is much lower than what you or your client deserves. Show the other side how their needs will be met. Don't give anything away without getting something in return. Don't take the other person's behavior personally. Negotiations should not be based on emotion. Sometimes people dig their heels in and refuse to settle a matter simply because they don't like the comment their opponent made during the negotiation. It is important to put your emotions aside during a negotiation. Thank you for watching. This concludes today's video.